welcome everyone to the 𝗟𝗂𝗄𝗅 webinar in relation to the EU securitization regulation and a particular spotlight on the Luxembourg market. I'm Louis-Maël COGIS and I'm very pleased to be joined by three panelists, Natalja Taillefer from Loyens Loeff, Markus Zenz from PwC, and Tomasic from Dechert. A quick word on the 𝗟𝗂𝗄𝗅. That's an industry body that has been constituted on the 1st March 2019, and within that industry body, we've set up a specific group to deal with securitization regulation, and we're very pleased to be able to present part of the outcomes of that group. Basically, the webinar will be organized in two sections. There will be first a presentation by the panelists of different elements we deemed important in relation to the securitization regulation. The first one being the purpose and scope of the securitization regulation, with a particular focus on the concept and briefly certain rules that apply to securitization. We will then have a brief overview of the Luxembourg framework. Then we will have a particular focus on a specific topic we deem important, which is the tranching within the securitization regulation. And then we will speak about the risk retention and contamination risk. So that's for the first section. The second section will be for you to ask questions, and we will try to answer those questions as best as we can. And you will have, through the platform, the opportunity to raise the question in writing, and I will try to select the relevant panelists to answer that question, and we will try to answer those questions, or as much question as possible, within the time frame that we have, which is, I think, around 45 minutes. So thank you again for joining us. And without delay, I will pass on the floor to Thomas for the first part of the section.
Thank you, Louis-Maël, for this introduction and presentation of 𝗟𝗂𝗄𝗅. So we'll start with the purpose and scope of the securitization regulation. And before diving into the regulation, it is important to know its background. So the regulation is considered as a cornerstone of the EU's effort to establish a capital market union by creating a single market for investment services and activities, and to ensure a high degree of harmonized protection for investors in financial instruments. It started with a communication of the European Commission released on 26 November 2014, and an investment plan for Europe, in which the European Commission has announced its intention to restart a high-quality financial markets and the development of simple, transparent, and standardized securitization markets after the last financial crisis. The regulation has been prepared and then published in the official journal of the European Union on 28 December 2017. Its application date was 1st January 2019, meaning that it applies to securitization having securities issued on or after such date, and to existing securitization that have created new securities or new position after such date. The purpose of the regulation is to lay down a general framework of the securitization. In this respect, the regulation defines what is a securitization. It established a due diligence requirements, creates risk retention and transparency requirements for parties involved in securitization. It set up certain criteria for credit granting and certain requirements for selling securitization to retail clients. It also established certain requirements for the SSPE, which is the so-called securitization special purpose entities, as well as condition and procedures for securitization repositories. The regulation also provides that certain securitization transactions can be treated as simple, transparent, and standardized securitization transaction, the so-called STS, if they satisfy certain criteria. On the scope, the regulation is quite broad and applies to institutional investors, originators, sponsors, original lenders, and the SSPEs. We'll come back with more details and on the main input of this regulation later on this presentation, and we'll first make a quick refresh on the concept of securitization. So as you may know, the securitization is the process of taking an illiquid assets or a group of assets and through financial engineering transforming it into a security. It is a transaction or set of transactions that enable a lender or creditor to refinance a set of loan, exposure, or receivable by transforming them into tradable securities. So, as you will see, the definition of the regulation is a bit different, and the regulation provides for the definition of securitization, to be considered as a securitization under the regulation. A transaction or a scheme needs to first have its credit risk associated with an exposure or a pool of exposures. It needs to be trenched, and it needs to have all of the specific characteristics which are listed under Article 2 of the regulation. So in other words, the three characteristics mentioned on this slide should be present. So the credit risk means that payments in the transaction are dependent upon the performance of the exposure. It needs to have the tranching, meaning that the subordination of tranches determines the distribution of losses during the life of the transaction. And it should not qualify as a specialized lending, meaning that the characteristics listed under the Article 147 of the Capital Requirement Regulation are not present. The characteristic, in a nutshell, is that if the exposure is to an entity which was created specifically to finance or operate physical assets, if the contractual arrangement gives the lender a substantial degree of control over the assets and the income that they generate, or if the primary source of repayment of the obligation is the income generated by the asset being financed rather than the independent capacity of a broader commercial enterprise. In practice, this last criteria of non-specialized lending is the one being precisely assessed to know whether a transaction falls or not within the scope of the regulation. Now that the scope and the purpose have been briefly explained, we can move on the rules that are applicable to all securitization under the regulation. It should be noted that we can, I think, move to the next slide. So, thank you. Thank you very much. So it should be noted that the regulation does not only create obligation for issuers and their related parties, but also sets out, for instance, due diligence requirements for certain investors, institutional investors. And as you may know, the regulation requires such institutional investor to perform some verification prior to all the securitization position. These verifications are depending on the quality and place of establishment of the originator or the original lender. The verifications are on the underlying credits and whether they have been granted on a well-defined criteria and on clearly established process to ensure that such credits have not been made to borrowers who are unable to pay back. The verification should be made also on whether the risk retention is disclosed to the institutional investor. In addition to this verification, the institutional investor should also perform some due diligence prior to all the securitization positions. So this due diligence should be made on the risk characteristic of the individual securitization position and on the underlying exposure, on the structural feature of the securitization that can materially impact the performance of the securitization position, which include contractual priorities of payments, payment-related triggers, credit and liquidity enhancements, and so on. Also, the due diligence should include, if the securitization is the STS securitization, whether the compliance with the requirement for qualifying as a STS under the regulation, for instance, the monthly or quarterly report or the documentation, are fulfilled. One other consequence of qualifying as a securitization under the regulation concerns the reporting requirements. So in a nutshell, the reporting requirements arise from the regulation on the transparency regulatory technical standards, which specify the information and the details that should be made available by the originator, sponsor, and securitization special purpose entity. That is the so-called RTS. Investors and potential investors in the securitization need to be able to conduct, as mentioned, the verification and the due diligence requirements. This applies also from a different perspective, but to the European Supervisory Agency, the European Systemic Risk Board, and the supervisory authorities, which need to be able to meet their respective mandate, meaning that to monitor the overall functioning of the securitization markets. The template of the RTS specify what information should be disclosed and are produced and available on the 𝗟𝘂𝗅𝗂𝗏 website, on different formats, but on the 𝗟𝘂𝗅 website. In a nutshell, the main information that should be disclosed are for all securitization, for example, the information about granularity, the information about having material impact on the performance of the securitization, which are contained most of the time in investor report, the information about the inactive exposure, meaning that any underlying exposure of the securitization that are being repaid, redeemed, cancelled, and as such does not contribute to the risk profile of the securitization. And for public securitization, meaning securitization having securities being issued through an offer to the public, meaning that they need to produce prospectus, whether there have been a significant event or information that would lead to having so-called inside information that should be disclosed also under such reporting. So the reporting frequency could be monthly in case, for instance, of an asset-backed commercial paper transaction, or quarterly for other types of underlying assets. And what is important to take back from this reporting requirements, that the obligation under the RTS are not specifically limited to the EU established originator, sponsor, or SPE, and therefore they may have a potential extraterritorial effect. I will leave the floor to Markus, who will probably come back with some more information on these reporting requirements and whether they need to be audited or not.
Yeah, thank you, Thomas. Well, I can already give feedback to that last point. So let's say the good point, this very detailed reporting is not subject to our annual audit of the vehicle. However, if now none of the parties mentioned by Thomas would do the reporting, then we have the competent authorities. So in Luxembourg would be the CSF, who could put administrative sanctions on it. So the reporting has to be done, but it's not explicitly audited by us if it's a Luxembourg vehicle. And that leads me now to the, let's say, next topic, the Luxembourg context of all this. So all those obligations which Thomas has just mentioned, does it mean they are applicable now for each and every Luxembourg securitization vehicle? So there I have the, let's say, good answer. No, the Luxembourg securitization law has a different definition than the EU securitization regulation. They are overlapping in a certain part, but it's not the same. So the Luxembourg definition is not only speaking of credit risk, which is securitized, but of risks in general. So it could be physical assets, it could be parts in an investment fund. All those would not be EU securitization, but they are in the scope of our Luxembourg law. And the second part about the tranching, where Natalja will give us some more insights afterwards, is also not an obligation for Luxembourg. So we can have unitranched securitization vehicles. So far, the obligation is to issue a security where the risk depends on those, or the performance depends on those risks which are securitized. With the potential modernization of the law, it doesn't even have to be a security anymore, but could also have other forms, like the EU securitization regulation also not only refers to securities. So we can say the Luxembourg law gives a very large frame. So we just saw on the slide before, we count around 1,400 vehicles by mid of the year. Out of those, they are not all EU securitizations, either because they're already older, or what we see is that they are not having tranched securities. So that is very often one aspect an arranger looks into, saying, I have here a loan or a loan portfolio, but I don't want to fall under this regime with all those obligations. So what can I do, let's say, to get out of it? And one of the possibilities is to not have this tranching, but as we will see afterwards from Natalja, that's not always that straightforward. So then the question may come, yeah, okay, we know now 1,400 vehicles in Luxembourg. How many of those are EU vehicles? How many of those are so-called STS, simple, transparent, and standardized vehicles? unfortunately, there's no register of EU securitization, so we cannot say how many these are. It's more like an impression. What we can say is, out of these STS, so those vehicles all over Europe, they're investing around 70% of the assets into trade and lease receivables. And that shows that it's going into the direction what Thomas mentioned at the beginning, that the purpose was to finance, to get the European capital markets to life, to finance to finance the real economy. So that we see that's happening, and that's also asset classes which we historically saw in Luxembourg. So that is also, let's say, a positive aspect for us. Yeah, and I think that's it from me on putting in scope Luxembourg compared to the European regulation. And there I would now hand over to Natalja to give us more insight on the tranching, which is in most of the cases the decisive factor if it's the one or the other.
Thank you very much, Markus. I'd like now to take one step back to the definition of securitization as just recently explained by Thomas, and in particular to one element, which is tranching. Can I have the next slide, please? Thank you. So tranching is really very simple on paper, but as it often happens in life, once you get down to the actual structuring, it becomes much more complicated. So let's start by taking a look at the definition. So what it says that tranche means a contractually established segment of credit risk, and I want to stress out contractually established because really it's one of the most crucial aspects that we will be talking about in a minute too, where a position in this segment entails a risk of credit loss greater or less than in another segment, so you have subordinated debt and senior debt, and without taking into account credit protection provided by third parties. So in layman terms, if you have senior debt and you have junior debt, here comes your tranching and you fall within the scope of the securitization regulation. As I mentioned, unfortunately, it is much more complicated in practice, and a lot of questions tend to emerge when you look at a particular structure. So I will just now try to go through these questions. I'm afraid that the format of this presentation will not allow us to go into too many details, but I'll try to cover as much as possible. So first point is, as pointed out by Thomas and by Markus, actually both, unlike the name of securitization suggests, the EU securitization regulation does not require the issuance of securities for a transaction to be captured by it. So when you analyze in the existence of tranches, do not think only in terms of securities. So any kind of debt, or even taking one step further, any kind of payable should be taken into account. And that leads us to the next question, which is again very much discussed on the market, is where the share capital can possibly be considered as a tranche within the meaning of EU securitization regulation. And now I wish I could give you a yes or no answer. And I start understanding that people don't like lawyers because that's what you never receive. But I cannot give you that. That's as simple as it is. Because if you look at ordinary shares in a limited liability company with no bells and no whistles, very simple, then your answer is most likely no, you don't have the tranching. And this is due to the fact, or rather the small wording you have that I just pointed out, contractually established segment of credit risk. So the subordination in case of ordinary shares in a limited liability company is not a matter of contract. It arises by virtue of the law. And although 1915 law does not have an express subordination provision, nevertheless, you cannot distribute profits to shareholders without, at least accounting-wise, deducting your liabilities first. So fairly simple for shares in limited liabilities companies, but once we take another step and let's look at partnerships, for example, which have a much more contractual character, or let's say subordination funds, this area becomes more and more hazy. The problem with this type of vehicle is that there is nothing in the law about distribution of profits, and this is regulated most often in your partnership agreement or in your management regulations if you're talking about securitization funds. So here you may very well have a question of whether we are talking about contractually established segment of risk because it's in your agreement, right? Or there is still certain room for negotiation to argue that no, it's still statutory and should not constitute a tranche. Even if you're talking about shares in a limited liability company, you may have to pay attention if you have certain bells and whistles attached to the shares. So if you have different classes of shares, for instance, you have hybrid instruments, then you need to be much more careful with this. And really, if you need one takeaway from what I'm saying right now is that when it comes to analyzing the share capital as separate, you really need to assess it on a case-by-case basis. So there is no simple yes or no answer. So the next point that usually people tend to ask, and that we even discussed it between ourselves when we were preparing for that, if you have two different tranches, but which rank senior and junior respectively, but you have one single investor, should you be looking at the de facto situation when both of the tranches are actually held by the same person, or you should look at how your documents are drafted? The general accepted position right now is that you should be looking at the structuring of the transaction from the perspective of the securitization vehicle. So you're looking at the drafting rather than who holds the securities at the moment the transaction is entered. The rationale behind it is that your securitization vehicle is really subject to a lot of obligation if it does fall within your securitization regulation. And it should not be subject to securitization regulation only because the investor at some point of time just transferred the security to somebody else. So you should have some visibility at day one. So the general consensus right now is that even if you do have two tranches held by the same investor, if they have different ranking, then it should still fall within the securitization regulation. Another question that's perhaps less often met is time tranche transaction. So this is the situation when you have two tranches which do rank pari passu, but one has a shorter maturity date and another has a longer maturity date. The question might arise because it does look as if the first tranche has a better credit risk because there is certain chance that there may not be enough assets to repay the second tranche because it will happen later in time. So first, time-wise, the first tranche gets paid and then only subsequently the second tranche gets paid. However, this should not be constituted as tranching, and this is because you should be looking at these two tranches in a bankruptcy situation where those two instruments would still rank pari passu, would get paid from the bankruptcy estate pari passu. So this is not tranching within the meaning of EU securitization regulation. Structural subordination is usually fine. Hooray, I can finally give you a yes or no answer. So structural subordination is usually fine. Here we're talking about the situation when debt is incurred at different levels of the corporate structure. So let's say the senior debt is incurred by at the bottom level by a subsidiary which is closer to the actual assets, and the junior debt is incurred by a parent. So this is not. So the subordination in this case is not due to contractual arrangements. This is due to the corporate structure. So no tranching there. Another situation is a different rate of return. For instance, you can have some performance fees which kick in after certain threshold is met. As long as this the instruments which bear this feature still rank pari passu with others, this is not tranching. Multi-compartment vehicles, we're looking at the tranching on a compartment by compartment basis. We're not looking at the entity in a whole, and this is due to the fact that investors only have the recourse against the specific compartment. So there is no tranching between different compartments. This is simply not relevant. I'm looking that I'm running out of time here, so I will just probably mention how the new securitization law draft is trying to tackle the issue of problems you encounter when assessing whether or not share capital can constitute a tranche, as we just discussed. So the new draft law will have certain provisions which establish the rank of different instruments which can be issued by a Luxembourg securitization entity. So the idea behind it is again to have statutory subordination rather than contractual subordination to avoid the application of EU securitization regulation. What I have to point out here is two elements. First, that it will only be applicable to securitization vehicles within the meaning of Luxembourg securitization law. As Markus pointed out, this is not the same as securitization entity or SSSP within the meaning of securitization regulation. You can have Luxembourg securitization undertakings which are not subject to securitization regulation, and you can have normal companies not subject to securitization law, but falling within the scope of securitization regulation. So this provision would only be applicable to securitization vehicles which fall under Luxembourg securitization law. And might I mention that there's certain discussions on the market about how these provisions would be seen on the European level and how they would be treated by European authorities. So I guess this is it for tranching, and I'll pass the baton back to Markus, who will be speaking about risk retention.
Yeah, thank you, Natalja. Indeed, so I'm getting back to those obligations we have shown at the beginning. We mentioned reporting, Thomas mentioned due diligence, and one of the others is the risk retention. So what does it mean? After the subprime crisis, it has been identified that one of the issues was that the bodies originating the loans didn't have to keep the risk or part of the risk, but they could simply distribute the risk to someone else. And this originate to distribute had to be avoided in the future. That was already the case, for example, in the CRR. So for the banks, when they invested in such structure, they had to already take care of the risk retention. Now, since the securitization regulation, that is really a direct obligation for the originator, the sponsor, or the original lender, that when they are selling some exposures to a securitization vehicle, that they keep skin in the game. What does it mean? It's 5% of the net economic interest, it says. So kind of 5% either of the notes or of the securitization position issued, 5% of the assets. So there are 5 different methods to hold it, but they must have it, must prove it, and an investor must verify that originator, original lender, or sponsor hold those 5%. Now looking again at Luxembourg level, here usually we have the SSPE, the vehicle. So there is no direct obligation in the vehicle that something needs to be verified here. So it's really on the level of the originating party, maybe sponsor, and then the investor. And then maybe one small remark on the risk retention. There has been a change in April of this year with the so-called COVID-19 quick fixes. That the securitization regulation has been amended to introduce the concept of non-performing exposures, and that in those cases, the 5% are calculated on the, let's say, net purchase price, so after the discount which has been paid, and that even the servicer of those loans could hold this risk retention part. So that has been an amendment earlier this year. And apart from that, as I said, the risk retention is not a direct issue, let's say, for the Luxembourg vehicles. Speaking of Luxembourg, I would hand over then to Thomas, who will explain us a bit about the contamination risk we may see in multi-compartment vehicles.
Thank you, Markus, for the risk retention part. And indeed, I will come back on what we call the contamination risk. So we will divide this part into main sections, let's say. So first, what is the contamination risk and where does this risk per se come from? So the risk of contamination can be envisaged in the multi-compartment securitization entity, so multi-compartment SSPE. Such risk, it can be described as for a compartment carrying out STS securitization to trigger the application of the requirement for STS securitization to any other compartment of the SSP, which carries out non-SSTS transaction or excluded securitization. Excluded securitization meaning excluded from the regulation, or to trigger the application for compartments carrying out non-SSTS securitization, the rules of the SSTS securitization to such compartments. So basically, it's coming from the fact that in Luxembourg we used to having the, let's say, umbrella structure, where an entity is structured with several compartments, and there's no recourse between such compartments because they're segregated entities and assets. And also from the fact that the regulation itself does not use the term compartments. So as mentioned at the beginning, it should always be kept in mind that the definition of securitization under the regulation starts by a transaction. So meaning that every rule or requirement under the regulation is imposed on, which are imposed on securitization, are imposed on the transaction or transactions in plural. Meaning that an assessment or an application of such rule needs to be done on transaction by transaction basis. So as a result, the fact that the regulation is focused on transaction will in principle exclude the risk of contamination, either between transactions or between compartments within one SSP, due to the fact that, as said, we need to assess transaction per transaction. However, in any case, an analysis should be done at the transaction level for each transaction, despite the fact that they are from the same compartment or different compartment, or an entity having no compartment, to know whether they first fall into the scope and to see which are the regulation, I mean the requirements or the rules applicable to such transaction. And back to Luxembourg, and as mentioned in the paper, we can oppose the analysis that is made in the securitization to the one that is made in investment fund, where in investment fund, when you're having umbrella structure with one compartment qualifying as an AIF, the full entity is, let's say, contaminated and needs to apply the requirements applicable to AIF. Here, it will be on the transaction by transaction basis. So if you're having an entity having compartment or no compartment being falling into the scope of the securitization or the STS securitization, then you will just comply for this transaction and not for the whole entity. So that was for the contamination risk. Happy to answer any question.
Thank you very much, Thomas. Thank you very much also, Markus and Natalja. I think that will probably, and thank you for the insightful presentation you've made. I think that will lead us to the Q&A session. Obviously, on our side, we have also some pragmatical question and some element we can briefly touch upon as well. One that has been of interest recently was the sending of the transaction summary to the CSF, for instance, even though the approach when you have different jurisdictions involved is that we can contact the various regulator in each involved EU jurisdictions involved. But on that note, Thomas, do you have any advice as to how to send the transaction summary to the CSF and the content of it?
Yeah, sure. Thanks for asking. So broadly, when it comes to Luxembourg about notification, because we will speak maybe another moment if there's any several jurisdiction involved, but just for the Luxembourg side, when the notification should be done to the regulation authority, it should be addressed to the Commission de surveillance du secteur financier, the so-called CSSF. And since October 20 and the CSSF newsletter 237, initiators, sponsor, SSP, or their consultant advisor should use the address which is gfi@cssf.lu to submit any information or requests that need to be submitted under the regulation, and especially under Article 7 on the transparency requirement of the regulation. So on closing, that will imply to either file the prospectus of the transaction when the securities are to be offered to the public and the prospectus has been prepared, or if no prospectus has been prepared, then you should, file what is called the so-called transaction summary, which should be prepared in accordance with the requirements of paragraph C of Article 7, if I recall well, of the regulation. And such transaction summary should contain the details regarding the structure of the deal. It should include the structural diagram containing an overview of the transaction. Should describe the cash flows and the ownership structure. It should also include details regarding the exposure characteristics, cash flows, loss waterfall, credit enhancement, liquidity support features. It should contain details regarding the voting rights of the holders of a securitization position and their relationship to the other secured creditor. And it should also include a list of all the trigger events referred to in the underlying documentation that should be provided and that could have material impacts on the performance of the securitization position. The advice I could give here is that in case any doubts arise and based on previous experiences, the CSSF is fairly available to answer any practical question that could arise from such reporting, and there's some specific person in charge in the CSSF for this type of question.
Thank you very much, Thomas. I think we have some questions coming in already, which is a good sign. First one, because I had also a question for Natalja, but we can come back to that a bit later. The first question is, could the STS criteria prevent the application of the rules of Luxembourg insolvency law, e.g. concerning the suspect period, and in what way? Anyone to take that question? That's an interesting question, but I think we're probably speaking about different element here, about suspect period, liquidation of a securitization vehicle or a particular compartment, and the fact that the STS criteria can prevent the application of those rules. I'm not sure that's the purpose of the securitization regulation here. Is there any other question also as well? Otherwise, I can also already ask a question, and that was for you, Natalja, but when we discussed just before the webinar, that's the jurisdictional aspect, which is when you have some German investor, EU investors, and a vehicle that is outside the EU. What's the approach to be taken in relation either to transaction summary or the rules that apply here?
Yeah, it's a very good question, and the reason for that is that there are really no provisions to this effect in the securitization regulation. It's very unclear when it comes to the determination of jurisdictional effects. The general approach is that European entities and European investors should not be put to any disadvantage when investing into EU securitization vehicle as opposed to a third country securitization vehicle. And for this reason, exactly the same requirements would be applicable to the investors investing, let's say, into Cayman Islands, as long as the transaction falls within the scope of the securitization regulation. And in this instance, all the credit granting criteria, transparency requirements, and risk retention would still be applicable, and notifications would need to be made to the competent authorities in these jurisdictions.
Okay, thank you very much, Natalja. We have another question about those contractually, between brackets, refer only to liabilities of the SPV or also to the assets of the SPV. And this question has been complemented by the SPV, meaning that the SPV buys a receivable which include tranching. Would that, so if I understand correctly, whether we analyze the contractual subordination or the trenching at the level of the notes issued by the SPV, or also at the level of the assets purchased by the SPV? I think it's a question for you, Natalja.
Yeah, indeed. And yes, we are looking at the liabilities of the SPV. So we're looking at the payables at the SPV level and whether or not there is any trenching at this level. What's happening at the assets level is not relevant for the purpose of this determination.
Thank you.
Unless it's mirrored somehow at the liabilities level, of course.
Yeah, if it's a pure pathway and you replicate the same structure in that case. But then again, the trenching will occur at the level of the notes and not only at the asset side, or the underlying asset side.
Exactly, yes.
Yeah. Another question. In structures where we have multiple trenches, some players take the view that the most junior equity trench, the pure equity, cannot be the retention trench. What is your view on this? I think it's also in relation to trenching, Natalja, since that all the questions are directed to you, but also the risk retention. I think, Markus, you can complete that as well.
Yes, and that's again something that's discussed quite a lot on the market, the risk retention trenches and how they are to be structured. We have seen the transactions when the risk retention would be structured through the junior equities trench. Then again, it wasn't a plain vanilla structure, so it wasn't just ordinary shares in a SARL. So there was a certain level of flexibility. So to some extent, I would say it's possible, but yes, again, case-on-case basis.
Yeah, the regulation gives 5 methods. So either you have a vertical piece, the 5% of all the tranches issued, but one of the other possibilities is to have those 5% in the first loss tranche. So it is one, but not the only possibility to have that risk retention.
Thank you. I don't have other questions so far. So just to remind all the attendees to the call, you can use the platform to raise question and ask question to the panelists. So please feel free to raise those questions.